for having Thank you so much for having us here today and be able to share with some of you. I've definitely talked to some of you, but not all of you. And thank you also to our partners at the Colorado Asylum Center. We also work really closely with the Immigration Clinic at the Storm College of Law, as well as we've been working more with Casa de Paz and trying to refer cases to Remain when we can as well. We have a great team of students and former students. Ella, who recently graduated, but actually helped to court observation with the Colorado Asylum Center when she was an undergraduate during the Biden administration when we were looking at other court processes. Hasmeen, who you'll hear from, was also involved in that, I believe, when she was a freshman. Now she'll be a senior and is still on our team. And then we have a couple of graduate students, Jenny, who's here today, Letty, who couldn't be here today. And then we have some additional students who've recently started in other roles. I think one, Ishil, is in the audience, who's helping us with some interviews of advocates and attorneys, and some others that have recently started. But again, this is a partnership between the University of Denver and the Colorado Asylum Center, which is run by Christina Brown, an attorney. And I've been collaborating with her on and off for years, including a prior court documentation project, as I mentioned, during the Biden administration. But last summer, like many of you were there, seeing what was happening, especially in Denver Immigration Court, when judges all of a sudden started dismissing cases, with ICE being waiting to take people in. She was also hearing a lot of concerning things happen in the detained court in Aurora, and really wanted to revamp another kind of court documentation so that we could get in there and kind of be the eyes and ears for the attorneys, for the American Civil Liberties Union or the ACLU, or to even refer cases to those entities as well. And so Christine actually led a training at DU, which some of you may have even come to as community volunteers. We devised forums to track what was happening in court with Christina, but also with input from those who are more familiar with detained court, like the Rocky Mountain Immigrant Advocacy Network or Remain, as well as with Liz Jordan at the Immigration Law Clinic at DU. And what we've really actually kind of seen over time is while we have forums and we're tracking what's going on in both Denver's non-detained court and in the immigration court that's within the Aurora Detention Center, is that things change really, really frequently. So, of course, once we got up and started, what we were originally interested in Denver court wasn't happening anymore. But of course, they were doing a lot of other things in court, which we'll talk about later. And so, what's really important for our team has actually been to stay pretty small. So we can really guarantee that one, students have good kind of, paid or credit opportunities to do this work, but also so that we could make sure that we're getting good quality data and a lot of good qualitative notes of, how did this end up like this? Or what did the judge actually say? Or what actually happened in the courtroom? Or what was your access like? Which has also helped us being able to code new things over time when they come up. For example, the importance of having a habeas for a bond case, which we'll also talk about. And again, part of our mission here is to keep a good, transparent record and follow these cases the best we can over time, which we'll talk about has been easier in Aurora than in Denver for a variety of reasons, to be able to provide patterns to attorneys or those who want to file lawsuits or complaints, as well as to get them to folks like you, right? Not only members of the public, but especially ones who are activists and advocates of how can we work in coalition together with the kind of data that we have and the kind of data that you're able to gather and kind of partner in order to inform the public and policymakers what happens. And then again, we have a referral system to refer folks to legal assistance when I've been able to, or at least for some screenings. I'll pass it to you to come back.
Thanks, Rebecca. Thanks for that overview. So we did just want to provide a little bit more context for this detention center and for the Shutdown GEO campaign. I know there's varying levels of knowledge in the participants of this meeting. So the GEO Aurora facility has been open since 1987 as an immigration detention facility. And it was the first facility in which the US federal government signed a contract with a private corporation to operate an immigrant detention center. So it's always been a testing ground for what the government can get away with regard to their contracts with private corporations. The contract was originally signed with Wackenhut, which is now GEO Group. They just had a different name at the time. And so um, the Shutdown GEO campaign has existed in this format for about 2 years. So we have had 2 years of sustained pressure to close the facility permanently. And this is a for-profit immigration detention center. So that means that the federal government pays GEO Group per person per day for everyone that is detained inside of this facility. And people do have the supposed option to work for $1 per day inside of the facility. Not everyone who is detained there has that. But so folks will often opt to work inside so that they can afford to call their loved ones or buy food from commissary to supplement the lack of nutrition inside of the facility. And so this is obviously a very unjust system. And the Shutdown GEO campaign is made up of members who, some of whom have been working to improve the conditions inside of this facility since 2007. And so it's really important, especially in this moment, as a lot of folks are citing detention as a problem that exists within the Trump administration. Like, it's important to put this into the broader context and the history, given that it's been open since 1987 and that folks in our campaign have been trying to make things better inside since 2007 at least, and other individuals obviously since before then. And there are no incentives within the contract, which is between the Department of Homeland Security and the GEO Group, for them to do better. That would be like penalties or fines if human rights are violated, or if people's constitutional rights are violated, which is something that we see very often inside of these facilities. Another thing that is just important to understand, which a lot of folks already do understand, is that people inside detention are not guaranteed representation. And that is something that the Court Transparency Project will get into, obviously, and that is kind of a big part of the basis of their project, is the fact that these people do not have the guaranteed right to a lawyer. And so that makes everything inside of this facility, and as they try to navigate their cases, extremely challenging, financially and emotionally and legally. And a lot of folks do speak English, a lot of folks don't. And so it just presents a lot of challenges when people are not guaranteed that right, which should exist in the United States, that right to due process. And I also just wanted to kind of give like a brief overview of some different working groups that we have inside of our campaign. Our outreach team mostly works with engaging the public and engaging with people who have been in detention. So we have a listening project where we interview folks that have been detained and just allow them to tell their stories in a longer format, like an hour or 2 hour interview. As well, outreach works to like work with Aurora City Council and things like that. Our advocacy group works with elected officials and more like in the policy realm. Our comms group works on our messaging and making sure that we are rooted in our values of shutting down detention and prioritizing that. And then our advisory group is made up of people that have been in detention or have had a loved one in detention. So they help to strategically guide our work as a campaign. And as far as the current updates, again, a lot of folks are probably aware, but the detention center in Hudson is set to open within the coming month. This is a formerly closed correctional facility that ICE is attempting to repurpose to make it a new detention center in Colorado that would have capacity for around 1,200 people in a town that has a population of 1,600 people. And it's about 30 to 40 minutes north of Denver. So the Shutdown GEO campaign is also supporting efforts to prevent the opening of the Hudson facility. The town of Hudson is currently being sued for their negligence with permitting and zoning and different steps that they need to take to try to ensure the safety of the residents of their town and the people detained inside of this facility, the people who will be detained. And so, and then, yeah, just the last thing to mention is the current potential outbreak of tuberculosis inside of the GEO Aurora facility. There has been one confirmed case of tuberculosis, and different sources, including like The Guardian. The Guardian has reported 12 positive cases, but we do not know that for certain because Adams County Public Health and the Colorado Department of Public Health have not been granted access inside to investigate. So when these public health departments cannot investigate, we don't really have much information on what it has looked like to prevent the spread of disease inside of the facility. It's also a huge concern given that the staff inside of that facility enters and leaves every single day. They are out in our communities, they're in our grocery stores, and things like that. And we know that the contact tracing that is necessary to prevent the spread of this life-threatening illness has not happened. So this is something that is really important to name in this moment. This QR code is to our link tree where you can take an action step to call CDPHE and demand that they issue a public health order because this really is a statewide issue and also given all of the people who go to visit inside of that facility every day. You all can also easily sign our petition. That's a very easy step if you want to take that. We have our listening project, so we'll have a virtual listening session that is for Aurora residents in August, and would love to see some of y'all there if you live in Aurora or in East Denver. And then, yeah, lastly, just that tuberculosis campaign calling into the Colorado Department of Public Health so that we can support folks inside detention and also try to prevent the spread of this illness. And yeah, feel free to put any questions in the chat about the campaign that we can answer now or later, and we can also revisit at the end. But for now, I will pass it back to Rebecca.
Thank you. And I'll tell you again a little bit more about the setup, and then Ella will lead us into some of what we've found, and then Jenny and Hasmin will talk a little bit about experiences that they've had doing court documentation and what they've seen as well. Some of this I talked about already, but I wanted to back up a little bit because I know many of you are probably familiar with going to Denver Immigration Court, but likely less so with the immigration court inside GEO, even if you've been there for, a vigil outside or for even visitation. Inside. And so, as many know, we cannot park in the parking lot. We have to park on the street. You cannot bring any electronics into GEO unless you are an attorney or a staff member. And so we can only bring pen and paper. They change the rules all the time at the security screener. So for months, I was bringing a clipboard, so I had something to write on. Then they told me it was too sharp, and they confiscated it a few months later. So the rules are constantly changing. Once you have to actually give over your ID and sign in a book, including your address. So there's a lot of information that you're giving them. You have to give them your keys as well. And then you get a visitor or, observer badge to go in. You have to wait then in a room for a guard or officer to open a set of locked doors down a hallway, then to buzz and open another set of locked doors. And you'll see that's often where the legal consult rooms are. There's a bathroom there. You can't buzz out of that room. So I've actually gotten stuck there before until somebody came and got me because there's no way to call out. Then there's another buzz door. And you go behind, there's a hallway where, sometimes family members sit and wait until they hopefully may be able to go in and be there for a loved one's hearing. But generally, the guards won't let them sit with them. They won't let them talk with them. Especially if they're women, they'll make them go sit on the bench with the women, which is off to the side, whereas men are largely in the rows of pews. There's 3 courtrooms inside there. Denver recently got some new judges, as many might be aware, in Aurora. Before March, they were actually, because of all the judges that were fired, they were sharing judges with Denver, which was very interesting because they were considered Denver-based judges, even though they were there on a 3-month rotation. So they weren't actually allowed to be present in the courtroom. So they're only 25 minutes away, but they're sitting in their courtrooms in Denver, in their robes, presenting via WebEx in the detention center, which is just very strange in general. And to be really able to tell what's going on in those courtrooms. As Ark mentioned, people do not have the right, they don't have a right to government appointed counsel if they can't find an attorney. This is true in all immigration proceedings, including in Denver. Something that we've seen that's new, and we're still working through the data we've collected in Denver, is that I think the representation rate in Denver is actually lower now than it is in Aurora. But it's still quite low in a place like Aurora. We'll tell you about that. But that all gets weaponized against people. Many who are familiar or have been to immigration hearings are usually sometimes accompanying someone to their final hearing, right? Or maybe they've been a witness in a final hearing. What we see is most people don't get to their final hearing, right? We're watching these very early, what are called master calendar hearings, or MCH, as an acronym, but they're very similar to like an arraignments type hearing, but things are happening much faster, both in detention and not in detention. So not only do you have the judge, right, and the immigrant who's called up, but there's also an attorney representing the Department of Homeland Security in there. Many times it feels like it's two against one because the judges, as many know, immigration courts are not independent, right? Those judges are under the Department of Justice and the Attorney General. And as we see much very blatantly this year, they've been given very specific guidance when they're not happy with the rulings that they have been giving. And so it often seems like two against one, right? With someone who has no idea what's happening in these proceedings. And so we see people at very early hearings. Maybe it's their first master calendar hearing. Maybe they haven't even answered the pleadings yet. Maybe the Department of Homeland Security hasn't even filed them appropriately, which we see actually happen quite a bit. And now we have judges who don't even go through the process with individuals who say, if you just want to go home, raise your hand. And they'll like very perfunctorily go through those cases with either voluntary departure, which doesn't have the same legal consequences, but is still it's actually considered an immigration benefit. So when you look at who's offered relief, that's categorized under there, which really isn't sound like relief to me, but it's avoiding a removal order, which does have more legal consequences, especially if someone would eventually want to return to United States. And we'll talk about this a little bit more later, but how many people really never make it to the final hearing where they get to present their case in either sort of immigration process. And now as we're seeing all these measures that the government has developed, even as they've changed them over time, to deter people from pursuing those forms of relief, and especially when you're not guaranteed an attorney and the only way you have to work is a sort of voluntary $1 a day. How do you pay for an attorney? Especially if your family is struggling because their breadwinner is in detention. This creates a lot of stress, and we hear some of that coming out in these particular hearings. So again, we're looking at these are the kind of forms that we use. We have different ones for bond hearings, which happen where people are trying to get out of detention. But those are actually separately held from people's master calendar hearings, and a lot of people don't understand that. They proceed pretty separately. Their kind of removal case versus their bond hearing. But my forms when I come out of court, like, don't look linear at all. I have like notes all over the place. And so we always tell our observers, please try to upload stuff to we have a Google form quickly and type it, or you lose a lot of the information to memory. But there's so much else going on in the courtroom that we use it to help us fill out the forms. But then we also use, all that context information that we're analyzing, and then we can input it right into a database, both the narrative and the things that we're checking off on boxes, which you'll see we have actually analyzed a lot of that since from between October and June for the detention center of what's actually happening and some patterns. Some things that I can talk about this later that we're starting to do in this next phase is that we're actually doing a 4-month kind of pilot comparison with the Cleveland courts, mostly because I have a colleague there who has good relationships also with court observation and court watch and experience, and also with the legal community where we can really kind of get a pulse of what's going on, but also because they have very different state level laws of how people might get channeled into detention in terms of their direct collaboration with law enforcement and ICE, 287G agreements where police officers can act as ICE agents, and also that they use also local and state jails in addition to a detention center. So we're going to be looking at that. We're also going to be doing some interviews. Some of you have already participated, and hopefully we'll get more with different advocates, as well as attorneys. We can, and sometimes some former judges and people from U.S. Citizenship and Immigration Services, or USCIS, so we can kind of get a sense of like how has their work changed and how are they helping their clients, or what haven't what's new to them, right? Even many experienced attorneys who do asylum, they had never filed a habeas petition before because they never had to, and kind of understanding how that's unfolding, and then really wanting to share our findings with media advocacy and policy. And then really trying to get actually at more final hearings. Again, those are often more complicated to get access to because you do need the permission of the individual whose hearing it is, often through their attorney to attend those. But that will really give us a sense of that final step of the process. But, a lot of attorneys are telling, sometimes people are doing voluntary departure before they get there. Those are scheduled further out. We've attended a couple of cancellation of removal final hearings. But we've not been able to yet go to a final asylum hearing. So that's kind of a call to you all if you know someone that you're accompanying and they would like someone to document that. That's something that we really want to also bear witness to. I'm going to turn it over to Ella so she can talk a little bit about at least some of the things we found and we can flesh that out. I might chime in and then we'll turn it over to the students.
Perfect. Thank you, Rebecca. We can go to the next slide. So to preface, before I kind of give an overview of, who we've observed so far and all of our major findings thus far, I did want to preface and say that these are observation-based, meaning anything that I'm sharing today is not a representation of every single hearing that is going on at the Aurora Detention Center, and that these are selectively chosen sometimes. And so I just wanted to put that out there that there is data, publicly accessible data available on platforms such as the Transactional Records Access Clearinghouse that provides a better picture of everything going on. But part of what makes the Court Transparency Project so special is when you're looking at these hearings in particular, it is important to have those like a general idea of everything that's going on between all hearings. But in a lot of that, you miss the depth of what's actually going on behind, these motions and these arguments. And that's where the real information lies that can be very helpful to the community. So first, let's take a look at all of the hearings and individuals that we've sort of observed. So to date, we began observing in the fall of 2025. And as Rebecca mentioned, there's two different types of hearings that are going on in Aurora, those being master calendar hearings and bond hearings. And so far, we've observed 477 master calendar hearings and 117 bond hearings. So this graphic on your screen kind of gives a breakdown of who we've observed. So as you can see, across both master calendar hearings and bond hearings, the vast majority of respondents in these proceedings are male, which we're going to dive in a little bit more here in a second. Across both, Mexico is the primary country of origin across respondents, and there's some overlap with Guatemala and Nicaragua and Venezuela. And another really important graph that I think is essential for contextualizing a lot of our findings is respondents' criminal history. Historically, not too recently, but typically those who were detained were those with criminal convictions. And as time has gone on, especially during the Trump administration, that has largely changed. However, public rhetoric around who is detained has not. So as you can see, there's a lot of instances in which criminal history is not discussed in the case. But I want to draw your attention to the bottom right-hand graph for criminal history under bond hearings. Only about 5% or six total hearings out of those that we've observed have been for respondents with a criminal conviction. Around 15% are for those who have clear no criminal conviction. So I think this is really important for contextualizing a lot of our findings and understanding who exactly is being detained. We can go to the next slide. So now we're going to take a look at some of our primary findings throughout the course of this project. We can go to the next slide. So, as I mentioned earlier, there's a huge disparity between men and women and the populations of both within the Aurora Detention Center. This is actually in pretty stark contrast to what we see in Denver non-detained, where it's a lot closer to 50-50 men and women, which makes sense. You have a better representation of, the average population group. However, in detention specifically, this is not the case. As you can see, approximately like 86% of respondents in master calendar hearings and 80% in bond hearings were male. And many of these male respondents were documented by the CTP observers to describe themselves as the primary financial providers for their families here in the United States, or the breadwinners. And while this doesn't necessarily look that important on the surface, these demographic patterns can have really important implications. Um, and they raise some important questions about whether or not detention, in part, functions as a gendered removal program. The detention of primary breadwinners shifts the financial burdens onto detainees' families while eliminating the detained respondents themselves and their ability to work. Several respondents were documented to have expressed that they were unable to continue pursuing their immigration cases while detained because prolonged detention prevented them from being able to support their families or to pay for legal representation. If you're not allowed to work, how are you able to pay for an attorney? And this introduces a primary theme revealed in the preliminary results of CTP's data. Rather than the Aurora Detention Center being simply a place where a respondent awaits their proceedings, detention itself becomes a factor shaping respondents' ability to pursue available forms of relief. There's one really prominent instance that I've included right here from observation notes from CTP observers, where the observer for this day, which was a case from January 2026 of a Colombian man, and the notes stated that the respondent explained that his family depended on him and has done so for 13 years. The judge said thank you, but stated that she did not need an explanation. Instances like this are quite common, where respondents, often who are unrepresented and often male, express that they cannot afford to continue fighting for their case while detained because they cannot work. In other instances, they'll express that their families cannot afford to live without while they're being detained. You hear fathers talking about their children and husbands talking about their wives in regards to how am I supposed to help them live out there, pay for rent, pay for food. Colorado can be expensive. How can you do that if you're unable to work in detention?
And I would add that this is where it's actually really helpful to talk to some of those in the Shutdown GEO Coalition and some testimonies from those who'd been detained, because this obviously intersects with the poor conditions. I believe students once saw a man code in court, and they just whisked him out of there. They have no idea where he went. We were all at many of us were at the vigil where a man held up his A number to the window that we got down about a month or two ago. And he was actually in our database twice. We found him. And the first time he had appeared remotely via hospital bed. And the second time he had not found an attorney because he had been sick, even though he was out of the hospital. But they scheduled his final hearing anyway, and he was ordered removed. But he was actually still in detention, fighting that on appeal. And so these conditions are also part of that pressure from the guards, pressure from DHS, even to send people back to the very places they fear. So again, judges are supposed to ask, do you have a fear of return, right? And not sending people back to the places that they fear. But then you hear people saying, well, I would continue my asylum application, but not from here. Right? Is there any way I can do it not from here? And so they are, and they do still have a fear of return. Yes, but how can I do that here? And so we hear a lot of these cases where they end up with no other option. And so effectively, the government is sending them back to the places that they fear. We'll probably go to the next slide.
So the second primary theme is one of the clearest patterns that CTP observed was the disparity in representation rates between bond hearings and master calendar hearings. In bond hearings, the representation rate was close to a staggering 90%, while in master calendar hearings, the representation rate was around 41%. This means that 9 out of 10 people in bond hearings had an attorney present. But I do want to note that the 41% representation rate in the master calendar hearings is pretty close to that general representation rate provided by the Transactional Records Access Clearinghouse for fiscal year 2026, which is right around 39%. So in terms of accuracy, I did just want to bring that up. So then the question becomes, what does this massive gap tell us about who gets access to counsel and who gets access to a real hearing? First, it's really important to note that it's not easy to schedule a bond hearing without the help of an attorney. When unrepresented respondents have asked judges how to schedule a bond hearing because they have to be requested, they're not automatically given, many times the judge will simply tell them to file something called a kite request, which is, in other words, just a written request sent internally by respondents. But based on CTP observations, it appears that a lot of people don't even understand how to do this and aren't given much help in this process. Without the help of an attorney who may be able to coordinate with the judge to schedule a bond hearing on their behalf, or even just provide them with additional details on how to file a kite request, many respondents may not even be able to schedule a bond hearing without the additional help due to the confusing nature of the process. And this may result in the disproportionate amount of representative respondents between bond and master calendar hearings. Second, respondents who do manage to find their way to a bond hearing often have no idea what type of evidence they need to be prepared with. In 12 of the 13 bond hearings in which a respondent was unrepresented, the respondent withdrew their bond request during the hearing because they didn't have enough evidence, or in most cases, any at all. And then there's been some recent shifts in judicial practice standards to basically ask judges to provide an advisal to respondents on the type of evidence necessary in bond hearings, especially in the cases for those who are unrepresented. But our CTP observations so far have shown that there's a pretty big discrepancy between judges and how detailed and understandable these advisals are to respondents. And across both bond and master calendar hearings observed, CTP observers have noted that respondents without counsel may struggle to obtain and submit required documentation, meet their filing deadlines, especially for things like asylum applications, provide legal arguments, and understand the procedural impacts of their own statements as well as the outcomes themselves. However, it's really important to note here that adequacy is crucial. CTP observers have documented attorneys failing to appear in their respondents' hearings or appearing in odd places, like sometimes while driving a car and half distracted, um, withdrawing from cases without explanation to the respondents or their families, and sometimes even failing to understand immigration law and legal proceedings, despite being attorneys themselves. And some attorneys that have been observed aren't even experienced in immigration law specifically, and otherwise work in a separate field of law, such as tax or family law. Some judges have even expressed to respondents during hearings that they have concerns of attorneys taking on cases where the respondent may be statutorily barred or completely ineligible for certain forms of relief or bond, which raises interesting questions about the ethical obligations of attorneys who are balancing a desire to provide adequate representation and uphold principles of due process, while simultaneously inadvertently profiting off a system that appears structurally designed to ensure that the vast majority of people fail. And I wanted to bring attention to this quote here at the bottom, which is observation notes from a June 2026 hearing of a man from Ethiopia, where the observer wrote, "The respondent's attorney did not notice for the entirety of the hearings that the judge had called up a man who was not his client for the proceedings or for pleadings," meaning this man was answering questions that were not even his own to answer. He was confused, and even his attorney, who was appearing via WebEx, which is the court version of Zoom, essentially, um, the attorney didn't even notice that it wasn't his respondent. It only They only found out at the very end of the hearing when the respondent stood up and said, "I don't think that's my attorney." And the judge had to backtrack everything that had happened.
And that happens a lot actually with interpretation issues. And I know Jenny has seen this in different respects, but sometimes attorneys, just to make it the process go quicker, will waive interpretation for their clients in these early hearings. But then you'll hear the attorney getting in a fight with the judge and with the Department of Homeland Security. And one time this was happening for so long in a bond hearing, they didn't realize that the man whose case it was, his headsets weren't working for interpretation. And he kept kind of waving his hands around like, I don't hear anything, because they forgot that he was there, right? It's almost like, what are they saying when you waive interpretation? Or we have some judges now who want to get things through so fast that they refuse to provide simultaneous or consecutive interpretation, especially if the interpreter is on WebEx, and will say they're just going to give a summary at the end, which again, they're missing a lot of what is being said to their cases. And so, again, these are a lot of the discrepancies we hear. And a lot of this also has to do with the fact that Remain is no longer allowed into the facility to do these group rights advisals and has been more restricted to one-on-ones. So a lot of folks aren't getting this basic information. Judges are supposed to give a rights advisal at the first hearing. But until a class action in the end of February, they were not telling people the difference between voluntary departure and a removal. We once heard a man ask the guard, which one should I take? Which is better? That was very off-putting. they also weren't telling people how to even request a bond hearing. Some people did have them automatically scheduled because it was something they, like a box that DHS might have checked when they were detained. But mostly, again, sometimes the court would schedule it for them. Sometimes they'd have to submit a kite. But we heard so many people asking in those months, will I just stay detained here forever if I fight my case? Or is there any way out of here? Or how do I get a bond? And I think also this point that bond hearings and master calendar hearings are separate. So a lot of people don't understand when they've hired an attorney for their bond case, why 3 days later are they not at their master calendar hearing? Or during a master calendar hearing, they ask for a bond hearing immediately. We've actually heard a lot of attorneys do this. And they're like, well, that's not the way things are done. And I think one of the most devastating I heard was a man who had been granted bonds and then hadn't been able to post it yet. This is about a week later, had his master calendar hearing, and he didn't have any other avenues for relief, the judge said, except for voluntary departure. And he said, well, what about my bond? And the judge said, what bond? He said, the one I was given last week. And the judge said, who gave it to you? He said, you did. Right? That was the week before. But he hadn't been able to post the bond, and his proceedings were proceeding anyway. And he ended up with a voluntary departure order. And those are things that we often see because a lot of people are confused that those are two very separate processes. We can go to the next one.
So the next major theme that CTP has observed is what we have sort of begun to call weaponized incompetence, which is basically a term that we started using to reflect the idea that mistakes, errors, and negligence may be purposefully made and or not addressed as a way to negatively impact respondents' case outcomes. So, CTP observers have documented a lot of errors or problems that have occurred in court that we kind of view as completely avoidable. These include things like incorrect or incomplete translation, where I remember one hearing in which the translator was clearly not even translating the same thing that the respondent was saying, or trying to summarize it when rather than providing the exact word for word translation, which is what they're supposed to do. Things like regularly malfunctioning equipment. I think we might have accidentally gone to the next slide. There we go. Things like regularly malfunctioning equipment that is never fixed or replaced. It seems like every single time that I'm at GEO or even at Denver, the headsets never work and there never seems to be a fix for them. Misspelled names on documents that make respondents very hard to track or find, an inability to find respondents for their hearings despite the fact that they are detained. There's been several times in which I've been in hearings and the judge will call up a respondent and the respondent isn't in the courtroom. And the judge will ask the officer or the guard there to locate them. And they're like, we don't know where he is, as if this respondent is not in a detention center. Another really egregious one that we'll go into a little bit more detail later is missing or incorrect paperwork. And sometimes this paperwork does not have the proper signatures from DHS officials. And then another big one that we've seen is attorneys and judges who sometimes appear to be blatantly unaware of legal terminology, practice, and procedures. I've been in hearings where the judge has asked their clerk staff what the adjournment code is, or what kind of notes they should put in order to end the hearing, or what type of ending they're basically noting here. So I kind of wanted to return back to the idea of missing or incorrect paperwork by providing this example on missing initial bond determination paperwork. So when someone is detained, the Department of Homeland Security is supposed to file something called a Form I-286, which is also called a Notice of Custody Determination. This document determines whether a respondent can be released on bond, and if so, at what price that bond will be set at. When a respondent requests a bond hearing, they are not asking for the judge to determine the bond for them. Rather, they're asking the judge to redetermine the bond already set by DHS. The redetermination component here is what establishes the judge's jurisdiction in this context, or their ability to make a decision on that respondent's hearing. If the Form I-286 has not been filed or is unfindable, the judge lacks jurisdiction on the grounds that they can't redetermine a bond that was never determined in the first place. And it's important to note historically that these forms have always been filed. However, under the expansion of mandatory detention, especially under the Trump administration, it has become implicitly and even sometimes explicitly permissible not to file these documents. And even when they are filed, Some DHS attorneys will find ways around it to create ambiguity over whether the immigration judge has jurisdiction in a case. Sometimes they'll say things like, I don't have access to the system to check if this was filed, or I don't know, and no further questions are asked. And while on the surface, these can be written off as unavoidable mistakes or errors, the frequency and pervasiveness of them are definitely a cause for concern. A simple mistake here can cost someone not only more time in detention, but their right to due process and even their life here in the US. I wanted to bring attention to this quote here at the bottom, where a male respondent from Mexico, who was observed in December 2025, directly stated to the judge, and I quote, "I don't know when I was detained. They had a picture of me that was someone else."
And sometimes
Rebecca.
we see, oh yeah, I'll add that sometimes we see these errors, and so the judge will ask them to reserve their notice to appear. And at the beginning of the year, we saw at least them maybe giving them a few hours and calling them back the next afternoon. But now I see them literally print it out and give it to them immediately, as if you have time to kind of figure out what that form even means, like what the charges are against you. Is it the right person? So they'll just kind of reserve it immediately. Which brings up a lot of issues and not give the person time to say, well, do you want someone to look this over with you or a lawyer? But literally just be like, the officer, can you print it right here? And also with DHS looking for these forms, they don't even have to find the form. The judge will just say, can you confirm a decision was made at all? And one time, DHS attorney said his internet was down. Like one time, can you go check? Because there's an office for the Department of Homeland Security in the detention center, right? Can you ask somebody? And sometimes they'll give them like 30 minutes to do that, or a couple of hours, sometimes another day or two. And again, that's longer that someone's detained. And if the judge doesn't have jurisdiction, and we'll talk about this in other instances of this, like you don't even get to make a case for yourself. Like no one, you don't hear about your ties to the community or your avenues for relief. It's just the bond hearings almost shut down immediately. And meanwhile, someone has paid an attorney. And especially if not everything's interpreted, you have no idea why this is going on. And obviously, it's quite obvious that an initial determination had to have been made to detain the person without bond because they're sitting in detention without bond right next to the Department of Homeland Security. So, I mean, the proof is standing right there in front of them. And otherwise, it'd be an illegal detention as well. Let's go to the next one.
So the next major theme that came from the preliminary CTP data is that detention creates an interesting context for legal proceedings, as it means that respondents' case decisions aren't being made in a vacuum. Often, their choices within their legal proceedings are directly shaped by their experience being detained. And this comes to the idea of procedural exhaustion. So, this has been particularly notable in CTP observations by looking at the amount of applications for relief abandoned or given up during hearings. In a little over 35% of hearings, respondents had a form of relief on file with USCIS or with the court. And what that means is they've already filed the documents, they've potentially submitted evidence, and they're basically waiting on someone to rule on their application for relief. And it's important to note that this figure is likely an underestimation of the frequency of respondents who file relief throughout the course of their proceedings. As Rebecca mentioned earlier, we don't regularly document final hearings in which these relief applications are often discussed. So, notably, in 31 of these 35-ish percent of hearings where a respondent already had a pending form of relief on file, the respondent received an outcome of removal order or voluntary departure. However, this number doesn't paint the whole picture. In many of these hearings where respondents effectively give up their claims for relief, they'll mention things like, well, how am I supposed to successfully fight for my case while detained? Or I can't afford an attorney because I can't work and make money while detained. Or sometimes even, I can't stand to be detained any longer. It's no secret that the conditions in the Aurora Detention Center, which is run by the for-profit GEO group, have long been under scrutiny and don't have a lot of regulation and rules as to the standards at which they must meet. Another important thing about detention is that it expedites case outcomes. Sometimes in the non-detained court, cases can take multiple years to adjudicate beginning to end. In detention, hearings are typically scheduled no longer than 2 weeks apart from one another. And so, um, This can kind of create an interesting landscape as people are required to navigate a very complex and confusing immigration system, often without an attorney, on a very rapid timeline. And then, of course, difficulty accessing representation. So, many people then feel pressured to abandon their claims of relief because of the exhaustion and costs that comes with detention, pressure from GEO and ICE, poor living conditions, and general feelings of hopelessness. And while CTP observers aren't really allowed to step outside of the courtroom and really observe what's going on in GEO, a lot can be inferred from the words and behaviors of the respondents. For example, CTP documented one male respondent from Venezuela stating, quote, I am still afraid to go home to Venezuela, but instead of being here detained, I'd rather be there. The immigration court system is already confusing and overwhelming by design, and detention only further exasperates these conditions and can lead to this phenomenon of hopelessness and procedural exhaustion.
One thing I also wanted to distinguish, and it's something we're trying to get actually a better like handle on the dates, but a lot of these folks applied affirmatively with USAS for asylum prior to getting detained. Actually, we've seen a couple that we've been able to look at the motion history where it was like 6 weeks apart, right? They applied for asylum, 6 weeks later they're detained. We've seen that with a lot of people entered as unaccompanied minors. A lot of people with spousal petitions before USCIS, which in any other time, especially in non-detained court, would just be administratively closed if there's no criminal records. It just, why don't we let that process play out? And many attorneys in detention are asking Department of Homeland Security to ask USCIS, because they're under the same umbrella, to expedite those cases, right? Because these are cases where liberty's at stake, right? Someone's detained. And sometimes we see them say they do that. I don't know if they do, but a lot of times they say, I don't see why we would. And in one particular case, I remember we talked to sometimes families who are there in the lobby or coming in and out. And, you know, one of them saying, you know, I've been petitioning for my husband, right? For years, and they keep telling him to take voluntary departure. It's like, but he's my husband. And this was one of those at DHS that they wouldn't expedite. And they would say, well, it's, you know, speculative that he'd qualify. And they're like, well, why wouldn't he qualify, right? All the paperwork's in, everything seemed okay. But again, these detention hearings go so fast that individual actually did end up taking a voluntary departure order. And so a lot of this is also playing against how slow USCIS has gotten and the fact that even when they retain jurisdiction over someone's relief, in some cases, they still will say, well, we don't see why they can't be detained, right, while they're waiting for those forms of relief, which is quite horrible to see. Let's go to the next one.
So the last primary finding coming out of CTP's preliminary data is basically this idea of the impacts of mandatory detention and the resulting lack of jurisdiction in bond hearings. So, to give some context, mandatory detention describes policies that widen the scope of who can be detained and makes it more difficult for people to be released for detention, leading to higher rates of detention and longer time periods where people are detained. One of the ways in which this occurred was the effective criminalization of entry without inspection. While on paper, entry without inspection is a civil charge, it's been increasingly used as a means to summarily prevent access to bond to a massive group of detainees who may otherwise be eligible when using the criteria of flight risk and danger to the community. As you can see here, 1/3 of observed respondents in bond proceedings were noted, or not in this graph, sorry. And so when you're sitting there in the gallery, you can tell that many respondents and their attorneys arrive at their bond hearing, which is technically called a custody redetermination hearing, as I mentioned earlier, ready to present their case. And this comes along with a reasonable expectation, given that these are court proceedings, where the general expectation is that you are able to present testimony and evidence for evaluation by a judge. That's due process. However, many of these cases never even got the chance to be presented. Attorneys would sometimes spiral into super complex litigation on the ambiguous interplay between a bunch of different court cases, those notably being matter of Hurtado, Maldonado Bautista, and even matter of Q Lee. And a lot of this created an ambiguity into whether or not the judge even had jurisdiction. And as a result, a lot of these hearings would basically end almost as quickly as they began. There was never any actual discussion on whether or not someone would qualify for bond based on the typical evidence of them being a danger or flight risk. Um, and sometimes in regards to missing I-286s, that also goes back to another jurisdictional issue. And overall, it just means that respondents are being left stripped of their due process and are unable to present the basic facts of their case for the judge to determine eligibility based on the traditional criteria of flight risk or danger.
And I would add for many of these cases, like again, as we see 3/4 of them, there was no bond set by the judge, and like 90% are represented, right? And so the lawyers don't usually take bond cases if they're good attorneys or reputable that they think will fail, right? And still, the primary reason why the judges are saying no is because they're saying they lack jurisdiction. And what's interesting, and that started to change a little bit with the 10th Circuit decision, and we're following that. But there's still categories of other folks that are still subject to mandatory detention, which would surprise you, like anyone who entered on the CBP-1 application or through parole programs for Cuba, Venezuela, Afghanistan, Haiti, right? And now we're seeing those TPS ending, and those folks are still held unless they have a habeas order under mandatory detention. And we saw a lot of this play out with judges, especially when there was a court ruling in the middle of the year. A few actually, the judge had to rule it 3 times because the government didn't listen. But we would see judges at first, try to follow the law or the federal court order, but then asking DHS at the end of that, well, do I have jurisdiction? And DHS would say, no, they're under mandatory detention. And then the judge would just agree with them. And a lot of this had to do with a memo that had sent to judges by the assistant chief judge, telling them basically to ignore the federal court order and to continue things as normal. And then since then, it's obviously gone back and forth in litigation. And the 10th Circuit is one of those that now is saying that just because you crossed the border without inspection years ago, that's never the way we've understood things. These people should be eligible for bond hearings and release on bond, but that is likely going to, I think, end up in the Supreme Court because there still are court splits on that. And again, even when people are saying flight risk or danger, we're seeing that now wider. It'll be something like a traffic ticket, or it'll be like an unstable address, are really crazy things that you would never consider to be. I mean, to call someone a flight risk who's been waiting on their asylum application for 2 years in USCIS, I wouldn't necessarily call a flight risk, right? And now they're also saying if there's no avenue they see for relief, although it's often they can say speculative relief, they'll also say no to bond as well. And go to the next one.
So next, we kind of just wanted to give you an overview of what the outcomes of these hearings are looking like. Keep in mind, these are hearing level outcomes, meaning these aren't the outcomes of cases necessarily, but rather that hearing that was observed. And so if you look at the left pie chart, those are the master calendar hearings. As you can see, the vast majority, or actually, well, a little bit over half of them, were continued to another master calendar hearing. And continuation basically just means that that case is just progressing down the typical timeline, going from an initial group rights advisal to the respondent giving pleadings as to how they entered, to sometimes administrative hearings based on like applications for relief, all the way through a final hearing. Um, the next sizable portion then is the 12.8% of final hearings which are scheduled. Then, on the right-hand side, we've talked a lot about the cases in which bond was not set, but I do think it is important to talk about hearings in which bond was. The average bond that's being set is right around $11,741, which the range of bond that we've observed has existed between, $1,500 to over $50,000, with the most frequent commonly occurring bond being just around $5,000.
And I'll add actually that $50,000 bond. It just was for a man who had actually originally come from Ukraine to the US on a visa for cancer treatment and then filed for asylum when the war broke out for political and religious persecution. And he was considered a flight risk because his address hadn't been stable. And so, even though a bond is set, doesn't mean someone gets out of detention, which we'll talk about how we follow that. We also saw a lot of bonds appealed by ICE. Sometimes there's an automatic stay even put. Some judges are now asking, do you intend to do that? So there's actually knowledge of that, but that wasn't happening before. But they still often will appeal these bonds. And so then the person remains in detention while that is being appealed as well, or while they can pay it. We can go to the next one. And release on bond has really dipped under this administration. I think national data showing it used to be like 36 or 37% release on bond, and now it's about 7% nationally. I have to check those, but this is something happening nationally, and because of this expansion of mandatory detention, of not just detaining more people than before, kind of indiscriminately, but keeping them for longer and trying to prevent them from getting out on bond. Although obviously we do see people released, we've also heard of cases of people being redetained as well. Ella, do you want to do the next one?
Yep.
Or do you want me
So
to do it? I forget.
the next slide being the next slide.
Yeah.
Yeah, we can go to the next slide. So
Okay.
the next slide kind of overviews our case updates. And I think Rebecca briefly touched on this. But as part of, and this is actually a newer feature of the Court Transparency Project, prior to kind of taking a look at the case outcomes themselves, um, we had primarily only been focusing on the actual outcomes of the hearings observed. However, we quickly realized that that wasn't really painting a full enough picture of what's actually going on in these cases, as what goes on in a hearing can oftentimes directly impact someone's case outcome. And so, using those tracking methods, we were able to locate a pretty sizable amount of respondents. I believe there was only 20% that we were unable to find in bond hearings, and around 30% we were unable to find in master calendar hearings. And going through this, we were able to identify all of our unique respondents, basically because there were some, of course, that we were unable to find, as well as a lot of respondents that we quickly realized were appearing multiple times in our data set. Sometimes we observed 3 or 4 master calendar hearings for one individual, or a master calendar hearing and a bond hearing for one individual. And we wanted to identify that to kind of better understand what these people's cases are looking like. And so every single week, we have a dedicated CTP member who goes through and pulls the case outcomes for all of the various respondents we've observed. And these two graphs kind of give an idea of where these cases are as the conclusion of the phase one or the end of June of the study. Um, there's some there's a ton of detail on this graph, obviously. But some of the major ideas is that a lot of people who take removal order or voluntary departure are pretty quickly removed. Although sometimes this can get complicated when appeal is filed and someone is kept detained, even if they've already been granted a removal order. Um, there's a lot of cases which are released, whether that's to Denver or they move to a different state. Um, as well as some, random type cases where someone is transferred into CBP custody. We're still trying to figure out exactly what that means and what that entails. So yeah, I just wanted to give an overview of how we're kind of comparing those different facets of the project.
But I don't think we have anyone that actually has received relief. Like we're trying to like, does anyone want asylum?
Yeah.
And the cases that we've seen, we actually saw what someone win cancellation of removal, and we did have someone who had won asylum. Actually, we talked to this person afterwards. They had won asylum from the judge in detention, but were still detained, and the lawyer had to file a habeas to get them out of detention because their case is still being appealed. And so, and again, yeah, I think we saw one cancellation of removal, one, but all these cases, what happens is if we're certain that they're not detained anymore through voluntary departure removal, we don't follow those anymore, or if they've been released to another state. But if we see that they're still detained, we keep following them as best we can or try to attend their hearings. But I think it was the prior slide. I think those are really helpful advocacy tools too, because they're how you know when someone has a hearing. They're how you know if someone had a bond, but they still are in detention. We use actually access corrections a lot. I want to thank Greg Mortimer for teaching me how to use that. Because oftentimes judges won't say their full A number, or we can't get it by other means. But if we have the name correct, and we can often get the A number, and sometimes we have to guess countries in the Executive Office of Immigration Review database, because there, if we have the alien number and the country, we can see where the case is at. And then we just partner with some folks at this place called the Backlog, whereas if we then put an extension on, we can actually get access to the full motion history of these cases, which is something we're just starting to work with and analyze and see how reliable that is to match up with what we're seeing in court. But I think that'll be a really interesting tool to use. Should we go on to the next one? That's students,
Yep.
right? Okay. So maybe we'll ask Jetty to share a little bit about her experience in court, as well as anything that she wants to call attention to, and then Hasmin.
Sure. I think for me, the biggest things that I feel like I've noticed, just kind of based off of what Ella and Rebecca have already talked about, is just the incompetence and the lack of transparency that happens right in front of respondents. And it's very surreal to see that like it's just happening right in front of someone and they're abusing the inability someone has to understand something to like their own advantages. I specifically saw, I want to say this was probably in May. I went to GEO and there was a case where a respondent was going to go in and ask for voluntary departure. The judge called up their A number. They went up to the podium. Their lawyer or attorney was on WebEx through like they were like zooming in, I guess. And when the judge asked if the attorney was ready to go through the hearing, the attorney said, no, I would like time with my client if possible. I received some news that I need to discuss from a family member earlier today, but I haven't been able to contact them because despite what time the court hearings are scheduled for these individuals, they can be scheduled at 8:30, they could be scheduled at 9 or at even 10:30. They all go in at 8 a.m. And then wait for the judge to actually come. And then they're all in there regardless of what time they're actually scheduled at. So like this specific person had their case that was scheduled at 10:30. So the attorney, that's when they logged in and they weren't able to contact their respondent because they were in the courtroom the entire time, awaiting for their case. And so when the attorney asked for the time to speak to their client, the judge didn't even clear the courtroom. They simply like dismissed themselves and like left the courtroom, but they didn't dismiss like anyone else in the courtroom. So I was like still there overhearing kind of this I guess like advisal of rights from the attorney to the respondent. And they were both speaking Spanish. And I think what struck me most is that the attorney was trying to explain and very much feel like a friend to the respondent and say, like, this is the new information I got. I really want to help you. I feel like we can figure something out with the judge as long as you ask for me to be removed from your case. And that way the judge gives you about 2 weeks to find like new counsel versus if we simply just ask the judge if we can have more time to prepare, they're only going to give us anywhere from like 3 to 5 days. And so in light of this respondent, I feel like I could resonate feeling that that conversation felt like the attorney was trying to advocate for them and trying to get the most time to actually prepare to represent their case, because the individual and their partner no longer wanted him to get voluntary departure. And so when the judge finally came back in, the attorney flipped the script to English, and then all of a sudden it was my attorney hasn't been honest with me. They have not been disclosing all of the information. They have lied about like some of their whereabouts and when they entered and such. And it was just like a complete 360 to see him try to like feel like he was on his respondent's side when he was speaking to his respondent in Spanish, but then presenting very different wording and facts to the actual judge, which I feel like only hurt this individual's case probably more because of the way his attorney was describing his like lack of transparency as like lying. Um, and so he removed himself from, he asked for removal of himself from the case. And when the judge asked the respondent, he said, well, that's not what I wanted and that's not what we discussed, but if this is going to give me more time to find counsel, then sure. So I think that's just like the lack of transparency that not only goes on in like the court system, but between like attorneys and their respondents. And again, the abuse of the fact that respondents aren't fully understanding the capacity of what's happening, even if they're told one thing, something else could completely differently be happening. So I think that's just like one of the experiences I've had. And of course, there's like very many more to touch on in terms of just like the incompetence that goes on. Just yesterday, I went with one of the other RAs on the team, and the entire time we were there from 8:30 all the way up until we were there till noon, they were not able to find one person. The guard that mans like the hallway that you wait in until you're let into the actual courtroom where there is then your own individual guard per courtroom. He kept coming in and out of all of the courtrooms, counting, doing like a head count of everyone. And then the guards that would be in charge of like their singular courtroom would be like, well, at least like the courtroom I was in, he was like, well, I only have 21. And then the guard that was like manning the entire waiting area and like making sure respondents were being like escorted to where they needed to go, were like, well, this courtroom is supposed to have 22. And that was like the same conversation that happened every time that guard would step in and be like, okay, doing another head count, like if someone was going to magically appear or something. But that was like the consistency of the conversation between them. And I don't think they ever accounted for the 22nd person in the whole time that I was there. So, yeah, just I think those are just some of the stories that like pop out to me most and make me think about like what the court system and court observation really entails.
Well, as has mean to share. Thank you, Jenny.
Thank you, Jenny. Yeah, so I was the student who actually saw an individual code blue during court. So essentially, the judge had already called his number, but neither him nor DHS could really um, identify him. So once I guess a guard noticed that an individual wasn't breathing. They identified him as the respondent, and he was essentially on this wheelchair. And as they were pushing him out, another guard told him, "Hey, he's been asking for oxygen this whole morning, and no one brought it to him." So it kind of really does just speak to the lack of training or the lack of prioritization of training within these facilities. By this time, while all of this was going on, the judge had already called another individual forward. I'm not sure if the judge completely dismissed the situation, if the judge could see through the camera what was happening, which I doubt. And it also speaks to how controversial and problematic just the whole way um, individuals are being processed. Instead of having a judge in person, they're making eye contact, they're having that human connection. They're instead doing it via WebEx, which raises a lot of technical problems, not just for the judge, but also for the interpreter. I've seen so many reschedulings because of that. Um, and I think just one of the patterns that really has stuck out to me, and I've seen frequently when I have gone to GEO, is essentially individuals not really knowing the differences between voluntary departure and removal, and the judge oftentimes didn't describe the differences between those two and the indications it would have for future opportunities. And the times that it was explained to them, it was explained in a way in which had a lot of legal jargon. And to be completely transparent, I don't think the average US citizen would be able to understand what's going on. Um, um, Ella spoke of this again. Many individuals, there's a lot of political rhetoric stating that a lot of individuals detained are criminals. These are individuals. I've seen many males come in, breadwinners. They own businesses, several businesses. They're active members of society that volunteer at their local churches. And a whole bunch of other places. So I think those are just a few stories and patterns that I have seen throughout my time observing at GEO in particular.
And I'll add that one of our students today, who's not, I don't know if Sophia's on today, with one of the law students, actually observed the bond hearing of the woman who was picked up at DIA recently, who or you should have just been released immediately, but had to have, a habeas and a bond to get out of detention, who was granted bond today. And then one other thing I wanted to flag, and Hasmin was there that day, was that one time the fire alarm went off in the middle of the hearing, and there's no windows in these courtrooms. We're like, there could be a fire. I have no idea. We don't have phones. Like we didn't, half the time the clock doesn't work. We didn't, and the judge just kept going. They're like, can everybody hear? And they just kept going. And I asked Hasmin, she's like, oh yeah, this happened like a week or two ago too. So just some of those things are just incredibly disconcerting and disregard for safety. Again, like the AC hasn't been working and they knew there would be power outages. So last week there was a power outage in the middle, and that means people's hearings are delayed another, 2 weeks, just because of these, how much money are they getting that they can't work the AC and the power and the internet? Or the fire alarm just seems it's egregious. Should we go to the next one? And Ella, you want to do the last two?
Yeah. So, at this point, we've shared a lot of data, and there's a lot of ways in which you can get involved, both with CTP, both with AFSC, as well as just sharing our findings with the community. So, there are lots of opportunities to help us document immigration proceedings at Aurora, Denver, and the next slide we share is going to have our contact information if you're interested. The one thing with that is because of the level of training is that we definitely want people who are more willing to go frequently or who are really invested in this if you're interested in documenting. But at the same time, myself or any of the other observers, I know even if you're not there to document and just kind of want to sit in on a hearing to understand what's going on for your own knowledge, most of us would be more than happy to accompany you and sit with you through the proceedings. Um, if you're an attorney, an advocate, or a supporter in any way, we'd love if you shared your stories and experiences and observations with CTP. If you are an immigrant yourself or you're a family or friend of a immigrant or respondent in proceedings, we'd love for you to share your stories too. Of course, these remain confidential and anonymous always. As well as sharing our findings and some of the things we went over to with you today, with your friends, your families, your communities, because the immigration system functions because of the lack of transparency. And a lot of people who, might have quite strong opinions on, being pro GEO, pro ICE. A lot of it comes from a lack of understanding of what's actually going on behind closed doors. And the really important thing is that as much as we do to document these, the most important thing is sharing it out with the public. And then, of course, helping AFSC with court accompaniment. And then, as part of this, you would be more than welcome to collaborate with us to document these simultaneously. We can go to the next slide. So, right here, you can see all of our social media handles. They're all the Court Transparency Project. We have Instagram. We just downloaded TikTok and Facebook, as well as a LinkedIn page. The contact emails for both Rebecca, myself, and then our general contact if you're interested in being interviewed or have something important you'd like to share with us or are interested in observing, you can use that contact information right there. And then on the left-hand side is a QR code as well as the link for our website. If you're interested in looking more at our data, we're working on getting more things published onto the website, like blog posts, to kind of keep everything in the loop and make sure we're sharing things in real time as we're observing them. Okay. Well,
Thank you all
thank you
for
so much.
listening. We'd love to hear any questions or comments.
Mhm.
Yeah, thank you so much. Y'all can put any questions in the chat or just raise your hand or come off mute or comments or anything to add. I know there are folks here that have accompanied people in court before. So yeah, would love to hear from y'all.
Rebecca and Ella, I have a question. My name's Eric. Is there litigation happening about some of the procedures in court that covers what you witness and looks to have changed anything that you witness? Or is this area not litigated very well? Are you in a corner of advocacy on ICE that has been well litigated? Because I know they've lost a lot of cases. That's
I
my
mean,
general question.
Yeah, I mean, the answer is there's constant lawsuits. And so the one we didn't want to get into all the nitty-gritty, but these mandatory detention policies have been one which is stated by DHS in July, and then got basically confirmed by Trump's, reinvigorated Board of Immigration Appeals, the BIA. That was a matter of Yahuri Hurtado, which was denying a bond hearing to anyone who had ever entered without inspection anywhere, anytime. It could have been 3 years old. And you could be picked up 25 years later in the interior of the country. And that's been litigated a lot. There was, again, a class action suit and three different orders by a federal judge in Central California of saying there's a class action, then there's a final order, and now I've officially vacated that and actually is a seething 20-page order of how the government has no respect for the Constitution. It's quite seething. If anyone wants a copy, I'll send that order. And so then people were eligible for bond hearings, but we saw the way that judges in DHS was trying to get around that. And then the Trump administration actually sued, and it ended up being a pause so that mandatory detention proceeded again, except in the Central District of California. And then it's been taken up by all the circuit courts. So the 10th Circuit, the courts are split, mostly actually siding against the government. The 10th Court Circuit, which we're in, did decide against the government. So that's why we saw thousands of habeas petitions being filed. So it was the only way that people could get a chance to have their cases heard. And that's been actually hard on the courts. They shouldn't need habeas in most of these cases. But the 10th Circuit did rule that you should be able to get a bond hearing. And so now we're seeing that happen. But likely this is still ongoing to the Supreme Court. But that's why we share a lot of our data with lawyers, especially with Christina, with Romaine, so that they can get in the loop of, can we use any of this for lawsuits? One thing that they're really interested in us tracking is our access to court. And in fact, we've had better access to hearings in GEO than we have in Denver. And those are things they want to know about of preventing observer access. One thing, that we've been kind of highlighting is the way that those who entered as unaccompanied minors are being treated in bond hearings. And again, we're actually now meeting with some groups through Acacia Justice that have been doing different forms of court observation, and a lot of that is run by attorneys. And so part of us doing this outreach is saying, like, we have data. Would you like to use it, for any of these lawsuits or just to inform the public when those are happening so people can understand why they're being litigated and what those are about. But yes, there is, and even like when the asylum applicant being pre-termitted, that a lot of these things are being legally fought, but that takes a very long time.
Thank you.
Thank you. Go ahead, Meg.
Thanks. Couple questions. This is being transcribed. Can I get a copy? I got in kind of late and it's a lot of information that I would love a chance to review later.
Yes, we are recording it and it'll be on YouTube.
Perfect. Thank you. Also, when you ask for stories, I do DocuTeam through Corn, I guess, and I get, the stories of how their loved one was detained, and their story in terms of how long they've been in the country and where their case is at. Is that the kind of stories y'all are wanting? And if so, do you coordinate with DocuTeam at all?
Yeah, so we've actually been trying to look into collaborating with DocuTeam on this. We're not entirely sure what we can do yet in terms of that. But for now, as we're kind of figuring that out, if you personally are willing to share like your own experience, being a part of DocuTeam, taking these phone calls, how that's impacted you, any sort of general patterns you've noticed, that would be extremely helpful to us and greatly appreciated. But we are trying to figure out some ways in which we can collaborate with DocuTeam and share some information back and forth.
Especially because we could, get the stories anonymously. Like we don't want to reveal any identities. And we're actually working somewhat similarly now with Casa de Paz, where they're sharing like release data with us, but not names. So like what the release patterns look like, before the Trump administration and now day by day, month by month, so we can get a sense of like who's being released and when, or at least some broader patterns. So those are all things that we're interested in because they give us a really more holistic picture. Because we hear a lot in the waiting room, like there's a checkpoint, right? And between the Colorado-Wyoming border where they just pull people over, right? And we hear so many people saying like that's where they got picked up. And
Yeah.
so being able to like actually understand what's happening from a broader perspective, I think would help us a lot because we hear that more anecdotally.
I would love that. I also volunteer with Casa de Paz, giving snack bags to families as they come out. And man, the stories are just mind blowing. Yeah, if I could help somehow like that, I would love, love, love to.
That would be fantastic. So thank you. If you can drop your actually contact info in the chat, that would be wonderful.
I'll do that. Thank you all so much for what you're
Thank you.
doing. God,
Thank you.
amazing. Thanks.
Do we have any other questions? Anything else that folks want to add?
Hi. Uh, First, I want to thank you all for putting this together and doing all of this research. This has been a really enlightening and educational experience for me today. Um, I'm wondering with regards to the Hudson detention facility, if slash when that opens, um, if you have any intention of kind of expanding this oversight to that as well, or if you know of like a court system that would be on in there.
I would love to if we can continue to pay students. Our current funding expires soon. So if anyone knows, especially in coordination with the Colorado Asylum Center, Ella's actually been part-time kind of between both of us and helping, especially because she's applying to law school and had just graduated. So if you know any one who would like to help us do that, we would definitely be up for the challenge of doing that, especially seeing like what would be similar, what would be different, what are the strains that are going to happen. We just have to figure out how we would fund that because again, most all of our documenters or students are recent grads, and so while we love volunteers, I'm like very ethically against having our students who are already paying tuition volunteer. So I usually like to try to find a way to pay them or get them course credit for the work that they're doing.
Go ahead, Kathy.
Hi, my name's Kathy Bucher. I'm part of CFER and AFSC, and I've been involved with Court Watch and Ice Watch and different things over the last many years. I have a question, and I also really appreciate what you presented tonight. It's really, really important. My question has to do with, are you or does anybody have the bandwidth to be looking at specifically violence against women? Um, Violence against women, obstetric violence in the detention centers, things like that. Is there anybody who's been able to do that? I'm sure it's a huge project in and of itself.
I'm not aware, but we've heard some things just from Casa de Paz. I think they would probably be the ones who would know, especially with folks. They've told us basically people get released from GEO and the financial calculus doesn't work, which is often when the medical expenses are too high, right? But then we also hear a lot of cases of them trying, at least what they told us, of convincing women who are pregnant to take voluntary departure. But I know there was one woman, and I think she'd been in detention for over a year and had a baby at home. That they were trying to bond out. So like we hear those cases too, but I'm not sure how you would get at that without being able to get, access to the inside, which is really, really hard, but maybe through attorneys and the consults that they do. We've been looking at actually getting status as legal assistants so we can go in and kind of do any information or intakes with the attorneys, but we haven't been able to get that yet. And so really our only access is to the courtrooms at this point. But it's important.
Okay, thank you.
Any other questions?
I did want to add as well, if any questions come up as you're thinking about this or reflecting, or you hear about anything and you're curious, we'd love to stay in contact with you. So feel free if anything comes up to email us with a question at any time. We would either be happy to answer it via email or schedule a time to meet with you.
Yeah. And obviously, part of the reason we're doing this, we're glad we could partner with Shutdown Geo and AFSC, is so we can also learn from all of you because, and we've had some meetings over the past with, different groups doing this work, like Colorado Migrant Justice Fund, Remain, and AFSC. I think Harriet, you were on that one as well. Of like, there's so many folks doing different pieces of this work. How do we best come together, and how can we help the coalition. We really do want to be helpful, so let us know of ways that we know everyone is very stretched thin. So how could we sort of pick at different corners to help in the overall struggle? The other thing we definitely would encourage is any of you who are doing ICE Watch or court accompaniment, if you know someone who wants a final hearing documented, let us know. But also let us know if you see something, say something, and we will too, right? Kind of what are we starting to see? Like the last couple of times I went to GEO, the gate was locked. I don't know why, right? Or are we seeing these mega masters in Denver? And while we realize sometimes it's important to keep separate so that we can actually like maintain a relationship with the court because there are access, we definitely want to share these things so that everyone can stay safe and we can best support folks through their process and our different niches that everybody here plays. And we're just really thankful that there's a community, although it's small, that it's quite vibrant.
Thank you. Thank you so much to Rebecca and Ella and Yasmin and Jenny and all of the other students. Yeah, we are super grateful for the work that y'all are doing to document this very interesting reality inside of the courtroom. And yeah, we really appreciate you all over time doing this as well. And there were a lot of powerful comments that were made tonight and observations from you all about a system that is designed to be cruel and designed to break people down. And the courtroom is a really poignant example of that, and the incompetence that we can see in front of us as well. And that is shown also in the medical neglect, which was touched on and is very present in this moment with a potential outbreak of tuberculosis inside. So yeah, we know that the stakes are really high, and we appreciate you all uplifting the facts and the truth of what it's like inside of those courtrooms. And thank you to everyone that joined this evening. I hope that you can share something that you learned with a couple of people in your life who might not know as much about this. And yeah, once again, feel free to follow up with the DU Court Watch team if you're interested in working with them. We can, yeah, we can send the slide deck out as long as that is cool with Ella and Rebecca and folks at DU. But yeah, we can send that to you all on email tomorrow. So thank you so much. I hope everyone has a great night, and we appreciate each of you. Thank you.
Thank you.
Thank you.
Thank you
And thank you
all.
for, yeah, thanks for inviting us. And thanks also quickly to my colleague Lisa Martinez, who's on, and one of our students, Sheila Dikisi, who's also helping us with interviews, who is on the call as well. So I wanted to thank them as well. Thank you.
Thank
Bye.
you.